about a year and a half's delay. It's great to see you all, even in this fashion. This will be my last meeting as the chair and the last meeting as a Judicial Media Committee member. So I just wanted to let you know what an honor it's been, and that I'm going to be passing the chair on to the very capable Eric Parker. And I don't have one concern about that. Since we do have a lot of new members today, I thought it would be great if we could go around and introduce ourselves. And I like the way that Rhonda called the roll there just now. Rhonda, would you mind doing that again so that people can?
No, not at all.
All right.
You want to be okay, Judge Alexander? You want to introduce yourself?
Hi, good afternoon. I'm Joan Alexander. I am an appellate court judge. I've been a judge since March of 2000, serving mostly in the criminal courts, and I'm very pleased to serve on this committee with all of you.
Judge Albus.
Good afternoon. I'm Michael Albus. I became a judge in March of 2013, now 8 years. I've been sitting mostly in family court. I'm currently the presiding family judge in Middletown, and I'm the chief administrative judge for the family divisions. I'm very happy and proud to be appointed to this committee. Looking forward to serving with all of you.
Lisa.
I figured it out. Technology, not my strong suit. Hi, I'm Lisa. Yes, Alexander, I miss you. For a good number of years, I covered New Britain Superior Court as the crime reporter for the New Britain Herald, and now I'm freelance. I work for Hearst, I work for CT News Junkie, and the Connecticut Health Investigative Team, and I'm very happy to be a part of this group.
Thank you. Steve, are you there? Steve Busmeyer? Okay. Linda? Linda Semino?
Yeah, hi. I'm looking on my computer, but I'm speaking on my cell phone, so it's just too many clicks of whichever way am I. So technology. Good afternoon, everyone. My name is Linda Semino, and I'm the director of the Office of Victim Services.
Ty?
Hi, everyone. It's Ty Erickson. I'm the Executive Director for Superior Court Operations. I work in the Office of the Chief Court Administrator. It's nice to see everyone.
Melissa.
Good afternoon, everyone. My name is Melissa Farley. I'm the Executive Director of the External Affairs Division for the Judicial Branch, and I want to thank each and every one of you for your time and service to this committee. We very much appreciate and value your input.
John Ferraro, are you on yet? Okay, Bill.
Good afternoon, everyone. Bill Fish. I'm a partner with Hinckley, Allen, and Snyder. I've done media law for 30-something years. I'm also the president of the Connecticut Foundation for Open Government.
Thank you. Judge Gold?
Hi, everybody. It's nice to see everyone. I'm David Gold. I'm a judge since March 2000. I'm currently sitting in Hartford as a criminal judge, and I'm the chief administrative judge for criminal matters here in Connecticut.
Thank you. Judge Handy?
Good afternoon, everyone. My name is Susan Handy. I'm a judge trial referee. I've been on the bench since February of 1993 and primarily sat criminal for the extent of my career. I'm currently not sitting because I'm a judge trial referee, but I hope to be back in court sometime in the near future.
Paul?
Hi, Paul Harden. I'm the Chief Administrative Officer here at the Supreme Court, and for the appellate system, I was Chief Clerk of the Supreme Court before that. And it's good to see everybody.
Allison, who's live streaming this, just ask everybody who is not speaking to mute themselves, if that's possible. Thank you. Dennis?
I'm Dennis House. I have been covering news in Connecticut for it'll be 29 years this summer. I'm currently the chief political anchor at WTNH TV, the ABC station in Connecticut. Honored to be a part of this great committee. And a little fun fact I'll throw out there, Judge Omar Williams was my son's T-ball coach many years ago.
There you go. Judge Youngblood.
Hi, everyone. I'm Judge Youngblood, and it's nice to see everyone. I actually got sworn in as a Superior Court judge with Judge Gold at the same time, but it is great to be a part of this committee. I'm sitting in New London. I was sitting criminal for quite some time, and now I'm sitting civil. So it's nice to see you all.
Ed?
I had to unmute, I'm sorry. Good afternoon, everyone. I'm Ed Mahoney, and I've been a reporter in Connecticut for an embarrassingly long time, most for the Hartford Current. And I've been in and out of the courts for a good portion of that time and had an opportunity to meet many of you. And I look forward to working with everybody in the future.
Judge Oliver.
Yes, thank you. Hi, I'm Vernon Oliver. I've been a judge of the Superior Court since March 2009. I'm the administrative judge in Middlesex, JD, and I sit criminal, a little civil, and habeas.
Thank you. Eric?
Hi, I'm Eric Parker. I'm an attorney in Rocky Hill. I also spent 16 years at WFSB, and after a brief break from last fall to this spring, I'm now back there hosting their Sunday morning show, CT21. And if Karen felt she has no concerns about me taking over her very big shoes, I have several, but hopefully it'll all go smooth.
John Penny.
Good afternoon, everyone. I'm John from the Bulletin newspaper. I've been there for about 16 years, covering courts in Eastern Connecticut for a big chunk of that. And I have to thank Karen Florin, too, for floating my name for this committee. I look forward to it.
Thank you, John. Wait a minute. I lost myself here. Hold on. Chris.
Hi, I'm Chris Powell. I'm a columnist for the Journal-Inquirer. Used to be managing editor there. I'm a member of the board of directors for the Connecticut Council on Freedom of Information. And though I can't seem to get my damn camera working, I would like Rhonda to know I did wear a tie today.
Well, thank you very much. Let's see, Gary.
Good afternoon, everybody. I'm Gary Roberge. I'm in my 33rd year with the branch. I'm the executive director of the Court Support Services Division. And it's good to see many of you again from our previous committee, and I look forward to working with the new members as well. Thank you.
Thank you, Gary. Judge Seeley, are you on yet? Okay, she thought she had coverage for the afternoon in court, but it fell through, so she might be here late. Lauren?
I'm Lauren Fu. I'm currently a director general at the Crimes course and breaking news there for the last 8.5 years, and before that I was with the Middletown Press.
Lauren, do you have something wrong with the mic? It sounds like a little child talking.
Oh, I don't know.
Are you there?
Can you hear me? Sorry, technology not working.
Okay. We can. I don't know if something's wrong with your mic or something, but it sounds like a little girl.
I'm sorry, I don't know what's wrong with that.
Okay, well, I'll move on. Hopefully it clears up soon. Andy? Oh, okay, there you are. Can you talk? Lauren, does it work now?
I just unmuted myself. Can you hear me now?
No, it's not working. The sound, we can see you. Andy?
I want what Lauren's taken. Andy Tebow, city editor of the daily paper in Waterbury. I've loitered at a few courthouses and newspapers prior, and I'm older than Mahoney.
Thank you, Andy. Judge Westbrook.
All right, Lauren's a hard act to follow. Hi, I'm Dawn West. I was appointed to the bench in February of 2009. I currently serve as the administrative judge of the Tolland Judicial District, and I largely sit juvenile. Good to see you all again.
Thank you, Judge. Judge Williams.
Hi, Omar Williams. I'm sitting judge in Hartford. I'm sitting criminal at the GA 14. I thank you all for your cooperative work. It's great seeing all of you again. And Dennis House, I did see the shout out on This Week in Connecticut. I meant to congratulate you on your switch to WTNH.
Judge Bazzuta, are you here? Okay, she's a member emeritus, but I don't hear her. Also, if any of you have dealt with Ralph DeAgostine, he's at the meeting as well. If in case there's any questions regarding criminal files or that sort of thing. And I'm Rhonda. So with that, I'll turn it over to Judge Alexander and Karen.
Before we go on to the regular business, I received a letter from the Chief Justice that I would like to read to Karen for all of her service. Dear Karen, I wanted to take this opportunity to thank you personally for your extraordinary service to the Judicial-Media Committee. You have been involved in one form or another since the committee's inception, when in 2006, Justice David Borden appointed you to serve on the now disbanded Fire Brigade. Soon afterward, you came onto the full Judicial Media Committee, where you quickly distinguished yourself as someone fully committed to educating journalists about judges and judges about journalists. As the media co-chair of the Education Committee, you worked closely with your fellow co-chair, Judge Susan Handy, Eric Parker, and later Lauren Salou, to conceive and create some of the most imaginative, interactive, and fun journalism for judges programs. And then you turned around and outdid yourselves when it came time for the Law School for Journalists. I've been told by a very reliable source, whom I cannot reveal, that there was quite a bit of competition between the journalists and the judges in planning these events. Yet regardless, the end result was always the same: a first-class educational opportunity for all involved. You passionately championed transparency and accountability throughout your tenure. Our courts are the better for your voice at the table. At the same time, you worked hard to help your colleagues understand how the courts and their processes work, so that the final product accurately relayed what occurred. I cannot speak for the media, but I can assure you that every judge who has delivered a difficult decision or who came under criticism, wrongly or rightly, appreciated your emphasis on accuracy and fairness. Nor were you afraid to push the envelope for more access, whether it involved hospital arraignments or having cameras in homicide cases involving sexual assault. The discussions were spirited yet constructive, and you deserve much credit for helping lead the charge. Now, having said all this, I recognize that neither judges nor journalists are in a popularity contest. But Karen, what also stands out about you is that you're probably one of the most respected and liked journalists in New England. You have the ability to fight hard for what you believe in, while at the same time being a decent and kind person who really just wants to do the right thing. It is very effective way to get one's point across, and the Judicial Media Committee, the courts, and journalism have all benefited from this remarkable skill. We will miss you, Karen. No one is indispensable, but that does not mean certain people don't leave lasting impressions. You are one of those individuals, and on behalf of the Connecticut Supreme Court, the judicial branch, and myself, it has been an honor to work with you. Very truly yours, Chief Justice Richard Robinson. Thank you, Karen, again, from all of us.
Wow, that was so very kind, and it really has been an honor, and one of my favorite duties in the last 15 years has been serving on this committee, and particularly working on that subcommittee for events with Judge Handy and Eric and Lauren too. So thank you so very much, and I have to say that now we really assembled a dream team of a committee here, and I'm somewhat sad to see you go, but I'll be following your progress. Moving on to the business, we should talk about the hospital arraignments. Judge Alexander, would that be your topic, or Judge Gold?
Judge Gold is now going to be talking to us about hospital arraignments and the rule changes there. Oh, Rhonda?
Do you want to do the minutes from the last meeting?
All right.
Okay, we have to approve our minutes. It was so long ago. September 23rd, 2019. All in favor?
Aye.
Aye.
Okay. Anybody opposed or with corrections? Okay, we've approved the minutes from September 23rd, 2019. Now we can move on to the item number 3, the update on the hospital arraignments.
Well, apparently I've been asked to summarize the hospital arraignment rule, which I'm learning of at the same time you all did. We did finally, after many years discussion, both at this committee and elsewhere, get a rule proposed, and we hope that it will be in effect later this year that will allow us to conduct remote arraignments of those who are hospitalized at the time that they would otherwise appear in court to be arraigned. The press had for a long time been frustrated by most judges' unwillingness to allow press into the hospital room when we used to go to the hospital to do the arraignments. And as we began to develop some of these remote technologies during the pandemic, evidenced by our
I know that the Rules Committee is trying to do a lot of work, but everything has slowed down. But I know all of these were in the pipeline when I was the Chief Administrative Judge in criminal, and I know that they are on the agendas for Rules Committee to consider. Thank you, both of you, Judge Gold and Melissa, for your insight.
And by way of information on that second issue, there were cases where there was, there was somebody charged, particularly in a cold case, of somebody who had been sexually assaulted, or multiple victims had been sexually assaulted and murdered. And because of the rule that prevents cameras in courtrooms in sexual assault cases, we could not go in and cover the arraignments of those defendants. In one case, it was a serial killer. So that's why we started working on that, and it's been a long haul, but it looks like it's going in the right direction. So thank you for that. Judge Gold, Judge Alexander, I know, and Melissa as well, both did some hard work on that one. Are we ready to move on to item 4? Okay. Discussion regarding law school for journalists and journalism school for judges. Before the pandemic, our subcommittee had done, and in particular, Judge Handy had done quite a bit of work on a program in which we were going to visit the Board of Pardons and Paroles and watch cases and have speakers, and it was quite advanced in planning. Of course, that didn't happen. And this year now, the discussion turned to whether or not we wanted to do something virtually. And I'm going to let Judge Handy speak for herself in a moment, but my opinion was that everybody's a little bit burnt out, and it might not be a great idea to organize a virtual educational program, and perhaps to put everything on hold until we can do something in person next year. Again, I'm going to be leaving the committee, but perhaps the committee can meet again in September and review, revise, and see. Judge Handy?
Yes, I did speak with Karen a little earlier today. As she just indicated, a year ago, September of 2019, we started planning law school for journalists, which was going to be held in the late spring, early summer of 2020. And it was going to involve both probation, and Gary Roberge and I had met a couple of times with some of his staff about that. And I had also met with the chairperson, or the chair people of the Board of Pardon and Paroles, and we were going to have an educational program which was going to take place at the Middletown Courthouse. That had all been set up. We were going to have some speakers in the morning, and then we were going to have an opportunity to view the Board of Pardons and Parole conduct a pardons meeting. Needless to say, that was all canceled because of the pandemic. And subsequent to the cancellation, I did reach out to the Board of Pardons and Parole, indicated that obviously we were postponing our program. I had spoken with Gary. We talked about that as well. And I then found out from the Board of Pardons and Parole that now they are not conducting their meetings in person like everyone in every entity. They're conducting it by remote like we're doing today. I agree with Karen in that I think everybody's kind of zoomed out and meetinged out in terms of virtual meetings. And I think quite honestly, the success of our programs has been to have in-person interaction. And a lot of the programs that we've done have involved what I always called a field trip. We've gone places and seen things and done things, which has made the program, I think, particularly interesting to both the journalists and to judges. So it would be my opinion to just kind of put things on hold at this point in time, reconvene the subcommittee, early next fall, and see if we can actually move forward with something in person for, the late spring or sometime in the spring of 2022. And certainly if other people have opinions on that, I'd certainly like to hear them, but that's kind of where I'm at this point in time.
I would just say, maybe Karen, before you jump in there, as a member of the committee, I think that the program that was planned really was going to be of great benefit to the journalists who could attend. And I think it was something that really would provide a look at something we don't normally get to. I mean, Karen and I have been doing this, between us for a lot of years, and we came up with 3 or 4 parole hearings that we had attended all the way through and really covered. And we're people who are pretty experienced in this topic. So a lot of the reporters out there, I think, probably have been to very few, and that whole process is something of a mystery. So the fact that we've put in so much legwork and have such a great program ready to go as soon as the world goes back to something close to normal, I agree with that, Judge Handy. And then if we reconvene in the fall, we can, if we have to adjust or do whatever. But we had a really great program right there on the cusp of it. So I agree with what you said. Let's see where things go. And if we can make it work, we make it work. And I think people will love it. And if we don't, we'll adapt.
Okay. Thank you for that. Next item is discussion of the juvenile transfer law. At an earlier meeting, I think it was Judge Alexander's first meeting as the co-chair, we had a pretty lengthy discussion about this issue because it appeared that the media was going to be shut out from trials involving juveniles who were charged with very, very serious crimes. Judge, do you have an update, or should we turn to Ed Mahoney or Bill Fish to bring us up to date on how this has resolved itself?
I would like to have either Bill or Ed talk to us about it. Whoever wants to go first, that would be perfect.
Ed, do you want me to go first?
Yeah, go ahead, Bill. Take it away.
Okay. I'm going to jump to the end. The issue has resolved itself. Earlier this month, the current and the state filed a stipulation for judgment where the state agreed that the act is unconstitutional under the First Amendment. The district court has not acted on that yet, but we fully expect that it will do so. And so the law will be permanently enjoined. But let me go back to the beginning, having now given you the end of the story. I first heard about this at that last meeting last year about this law, and I'm going to be somewhat black and white and straightforward as I kind of go through what we did on behalf of the current, given that we've also named as defendants Judge Carroll and many of the clerks in their official capacity, which was a necessity in order to challenge the statute. And we did this with the Reporters Committee for Freedom of the Press, which was an essential part of it. They did it pro bono for the current, which was a very important part of being able to prosecute it. And they did an absolutely amazing job. If you've heard of them before, they're a very strong group that represents the media nationally. But we filed a complaint in December of 2019. We filed a motion for a preliminary injunction based on the First Amendment in March of 2020. Judge Shea granted that in July of 2020, and the preliminary injunction was against the closing of the court records. The law closes both records and proceedings for any juvenile transferred to the adult docket. And in the preliminary injunction, we took it in pieces and we challenged just the record keeping portion of that first. Judge Shea granted that, as I said, in July of 2020. The state took an appeal to the Second Circuit. That was argued in December of last year. And in February, they affirmed Judge Shea's opinion. They held that there's a qualified First Amendment right of access to the records, which is also what Judge Shea held. This is an important point because the state was arguing that it was the personal characteristics of the litigant, i.e. a juvenile, that should be an important consideration in determining whether the courts should be open or not. And the Second Circuit and Judge Shea said, no, that's wrong. It's the nature of the proceedings, not the personal characteristics of the litigant that matter. And because courts are historically open, as I think we all know, the Second Circuit, in a pretty strong opinion, found that the law was unconstitutional under the First Amendment. There's essentially no authority in the country that the state could cite to And in our view, that's because there's no other statute that was like this statute any place in the country. In fact, the lawyer at the Reporters Committee didn't believe me when I was first trying to explain what the law did. And so the Second Circuit held that the law was not narrowly tailored and that therefore it violated the First Amendment. And given that decision, that's when the state worked with us and we put together a stipulated judgment, which was filed earlier this month. So that's the long and short of it. Ed, did I leave anything out that you think you should add?
No, you haven't. Practically speaking, I don't know that anybody's really had a chance to see how things are working since those decisions because of the pandemic and the closures of the courts and the short staffing in the clerk's offices and things like that. But I will say I was down in New Haven the other day, and I'm not exactly sure from what I saw how the system is working. There were 3 cases which were closed, involved youths in that age bracket that we were talking about in this decision, and the cases were sealed, and some continued. Out of the 3, I think 1 or 2 continued to be sealed, and 1 was open, and that person was age 20. So I think and I haven't looked into this yet, so I don't know how the system is working, but from those 3, if you could extrapolate, it looks like what the judges are doing are following the advice of both courts that you can't have a blanket closure of cases, but they're just sealing everything on an individual basis. And they're saying that the compelling interest that the state has is to avoid damaging both physically and mentally somebody that's, 15, 16, 17, and 18 who's charged with a major felony. So I don't know how many are being opened and how many are being closed, and whether they were opened at, July 27th or so when Judge Shea issued his injunction, and whether they're opened and then subsequently closed, or whether they just remain closed or whenever opened or how it worked. But maybe at some point we can figure that out.
Yeah, there's, if I could add to that, Ed, there's a series of demarcations in time which have affected different cases differently depending upon when they had notice of the injunction proceedings, et cetera. All of that eventually will be, I'll say, swept away when the stipulation is finally entered and a permanent injunction enters. None of that keeps any judge in any particular case from doing what a judge has the authority to do in any particular case, which is close proceedings or seal records.
Okay. Well, thanks.
Karen, could I add something here? This is Chris Powell.
Certainly, Chris.
Along these lines, a few weeks ago, Alex Wood in the Journal-Inquirer reported that a rape case in Hartford Superior Court involving a juvenile defendant and a juvenile victim had simply disappeared. I guess Alex called Rhonda about this, and all Rhonda could tell him was there, wasn't any public record of the case. I hope others can see the interest in some disclosure here. I mean, somebody either committed a horrific crime or somebody fabricated a horrific crime. We don't know what it is. We don't know on what basis, what official made what decision to make the case disappear. I certainly think this is very much against the public interest. Back when I first started complaining about secrecy in the Judicial Department decades ago, the Judicial Department would often direct me to the 1968 State Supreme Court decision in Adams versus Rubino, which was construed to hold that the legislature can't make rules for the courts. Of course, I was urging the legislature to make rules to prohibit secrecy in the court system. Of course, we have lots of laws now, including the ones just determined to be unconstitutional that presume to make rules for the courts. I imagine that this rape case from Glastonbury, which was in Hartford Superior Court, has disappeared in accordance with one rule or another that the legislature has put into statute, either youthful offender status or something else like that. I get the impression here that the Judicial Department didn't like rules for the courts being made by the legislature when there was a possibility the legislature might pry the courts open. But if the legislature wants to enact rules for the courts that keep things secret, there's not so much opposition from the courts. I always return to the proclamation in the Declaration of Rights of the state constitution. All courts shall be open. And I wonder how that declaration squares with all this legislation, much of which has not been found unconstitutional yet. And, I don't know if anybody on the bench right now would like to address this issue, but I guess all I can ask is if maybe they keep this in mind and tell us someday, will that declaration and the Declaration of Rights, all courts shall be open, is that ever going to mean what it says?
Well, I appreciate your comments, Chris, and have always appreciated your candid comments on this committee. And I'm not sure what else there is to say, except we have to look at this now as on a case-by-case basis, given what's just happened with the current and bill. I'm not sure of the details of the sexual assault case that you just described. Is anybody familiar with any details enough to say in general what happened there?
Well, Alex's story had something. I think it was a Glastonbury case. The defendant was accused of raping the minor, and it just disappeared.
After how long, and how were you able to tell after how many court appearances, or?
I don't recall that in the story. Alex might know, but I believe the charge arose in 2019.
Okay, all right, and I'm sure that without any real specific details, nobody's going to be willing to talk about it here, but it should be something that the committee continues to discuss in terms of us having access to very serious crimes committed by juveniles.
Yeah, and I don't want to be seen as too much of a critic here. I mean, we all who've been around for a while know really the transformation that has come over the Judicial Department since Chase Rogers was appointed Chief Justice. I mean, this committee is really evidence of that transformation. Rhonda and Melissa are always there for us. There's very few questions we can't get answers to these days, and it's much appreciated. But the Constitution still says what it says, and I just don't think that's being lived up to. And I would encourage the Judicial Department to take the lead on this. I know the Judicial Department was not approving of this law that's just been found unconstitutional. As I recall, the department submitted a statement in opposition to it in the legislature. All courts must be opened or shall be open is in the Constitution. That strikes me as pretty good direction to any judge sitting in any court at any time.
Karen, may I say something? So, you all know the legislative process, and we respect the role of the legislature, and we hope that the legislature respects the role of judiciary. And most often, we don't provide policy thoughts on proposals. We provide to the legislature what it will take to implement it, and oftentimes we kind of help them with language. But I will say just this session that there is a bill that would require the judicial branch to seal eviction records, and it's sealed and unsealed at different portions of the case. And we did, in our testimony, make it clear that we believe that this particular bill is not in conformance with the mission of the judicial branch, which is to be open and transparent. And the bill was approved by the Housing Committee. So I would honestly just ask, we're all concerned about openness and transparency, and any assistance that you all can provide in the legislature would be very happy. There are bills right now pending that would erase tremendous amounts of convictions. One bill is mostly for cannabis. Another bill is going up to Class D misdemeanors. So well, I think we all understand the importance of openness and transparency, but honestly, I think a little help with the legislature would be appreciated.
Melissa, I've written a few columns about that stuff this year. I know the CCFOI is pursuing it. I think we may have to do a lot. It might be best if we call people racist or something that might intimidate them a little bit out of this stupidity. But I, certainly appreciate the department's attention to these matters, and particularly your help in regard to them.
Thank you.
All right, anybody else on that topic before we move on? Okay, hearing nobody, the next, and I believe last item on the agenda, or next to last, a discussion of how things are going with the courts during the pandemic. And I know that it's been a very long haul for all parties involved. I wonder, perhaps Judge Gold, could you bring us up to date a little bit on how things are going on the criminal side and when we can ever expect to get back to normal?
Well, I can try. It obviously has been a very difficult challenge for us over the last 14 months or so to deal with the cases that have come in on the criminal side, and it's been a challenge in many of the same respects in all the other disciplines, family and civil and juvenile as well. We never really shut the courts, as all of you know. We continued to work from last March when everything else was shutting down. We stayed open. We did at the beginning close some courts and consolidate business, but by the summer we had opened many more, and I suspect more will be open as we move forward. The biggest change has been remote technology. We have managed to deal with the cases that have been coming in by remote proceedings. If any of you have been in the courthouses, you'll know that we have pretty much eliminated defendants and others appearing in person in the courtroom, and instead have people appearing by Microsoft Teams. Many of these changes were long overdue, and I suspect they will continue even after the pandemic. Rather than having lawyers come to the courthouse to do pretrial discussions, the pretrial discussions between the judges and the lawyers are now held remotely, and I suspect that may continue even after the pandemic. But particularly on the criminal side, I think the criminal court process has always been a very personal one, in the sense that I think appearances in court have been an important part to resolve cases, and we haven't been able to do that. At the same time, we have not had jury trials. I know the Chief Justice is eager to begin trials again at the earliest date possible, but from the beginning, it has always been the safety and well-being of the stakeholders, the staff, and everyone in the courthouse that has been paramount. And many of you will recall that we had hoped to start jury trials in November, and then in October, the infection rate spiked, and we had to pull the plug on that about a week before we were ready to do our first trial. Since that time, we've been hoping and praying for a day when the situation will allow us to start jury trials again. What that date will be is still uncertain, but certainly as the vaccination rate has continued to increase, the branch will continue to look at the day when we can again feel safe in bringing jurors to the courthouse. And that will impact the processing of business, not only on the criminal side, but also on the civil side as well. So I think there are certainly many who have criticized the branch's efforts. We've been criticized for moving too slowly in reopening the courts, and at the same time, others have said we're moving too quickly. So it's been a difficult needle to thread, but we hope in the not too distant future, we can begin the process of doing jury trials again and return to something closer to what we had been accustomed to, enhanced, I hope, by some of the use of technology that we have adopted over the last year.
Thank you, Judge Gold, for that. Is there anybody from the media that would like to address their observations and concerns from their experiences covering cases, covering courts?
Hi, it's John at the Bulletin, if you don't mind, Karen.
Please, John.
So I've seen a couple things in just covering day-to-day court activities that when it comes to do with access, and it seems to have gotten a little bit better. One of the big issues early on was court dockets at times didn't bear any resemblance to what was actually happening in a court. I noticed it looks like they've started adding remote hearing on the website docket, which is extremely helpful. The only other thing I've seen is there's been times where it's been very close when it comes to the amount of people allowed in a courtroom, especially if it's a case of interest. And you've got family members, defendant family members, victim family members, to actually be allowed in the courtroom to report on what's going on. It hasn't happened yet where we haven't been allowed in, but it's been very close where we've almost exceeded the allowable people inside a courtroom. Those are the only two things I've seen lately.
Well, I'm glad to hear that the dockets have become, or they've been able now to better reflect the court's business on a given day. So we will, of course, continue to make things better as we move forward. And you're right, John. The size of the courtroom has created problems. I don't know in which courthouse you had that experience, but certainly our courthouses range from extremely roomy to some that are quite congested, and we have had to work within the CDC guidelines. The marshals and court ops measured the buildings to see how many could safely go inside, and we have to continue to use that as our guiding light as we move forward. As we attempt to increase the processing of business, we can't lose sight of the need to protect everybody's health and safety. I'm glad to hear that we never quite made it to the point where you were unable to be in the courthouse. But if that were to occur, I would hope that you'd reach out to Rhonda and Melissa, because we can, if it's brought to our attention, hopefully address the situation so that you'd be able to be in there.
I appreciate that.
Anybody else from the media?
Karen, it's Lisa Backus. Can I have a minute?
Please.
There you go. Thank you. My question, and I'm sure this has been considered or discussed before, maybe not, is there ever going to come a time when we can go online and get the paperwork for criminal cases, much in the same way we do for civil. And I just want to add to that. I literally have not stepped in a courtroom in 14 months due to a health concern. So Rhonda has been super helpful in, and everyone else, Ralph, I'll give a shout out to Ralph. Everyone else has been just tremendous in helping me still cover the courts, even though I can't be there. But overall, you know, I've thought about this a lot throughout the years. Will I ever be able to get an arrest warrant by clicking on that case?
Well, I'm reluctant to say if you'll ever be able to do it. You know, the criminal court continues to be largely a paper system with little of the material being put into a digital form. Certainly, there are efforts underway to try to modernize criminal as the civil side has already, and the family court has moved, if not continues to move in that direction. The fact that we're still a paper-based system has made it a little more difficult for us through the pandemic. But certainly, Lisa, your hopes to see things more easily accessed, I think, is shared by not only members of the press, but many others as well. So I'm sure that our tech people are working to that end, but at this point, we're just not there yet.
Well, thank you. Thank you for that.
Is there anybody that can speak to, it would be very helpful, I think, for the media members, what we might be able to expect when the moratorium on evictions is, I guess, shut off in a few months? That's a big one looming, and maybe it should be an item perhaps on the next agenda for this committee, at which I conveniently will not be part of. But I think that's going to be a big issue that there will be much written about. So that will loom. Okay. Any other new business?
Can I ask a question?
Sure, Andy.
I have an issue, I think. Suppose there's an AR hearing and the file has been sealed. How do you find out who the judge is or what lawyers are appearing? And I asked this in relation to another Alex Wood JI story that appeared this afternoon about such a case, and whether it's a stage 1 or a stage 2 AR hearing.
I think I can answer that. I know on the hi everyone, it's Ralph D'Agostine. I know on the website, the issue you face if there's a case in a diversionary program is the only thing that's disclosable is the name of the defendant and the docket number online. You would not know what type of program is in there. The proceeding itself is open, but if you were to look online and not know that it's in an AR program, for example, you wouldn't know. What was the exact issue in that case?
Well, it shouldn't the presiding judge be public? Like, shouldn't we know who that is or what attorneys have filed appearances?
From the website, no, the file itself is sealed. The only thing you would know on a diversionary program is the name of the defendant and the docket number. You would not know if you went to the website and I had a diversionary case and you looked up Ralph D'Agostine, you would see a docket number, and then it would say, if you tried to click on it, the case is sealed. That's all you would know. You wouldn't know who the attorneys were on the case. You wouldn't even know the charges.
Yeah, but there's a public hearing that's coming up. So it seems weird to hide the name of the judge or the attorneys.
But the judge would not be available on the website.
Oh, okay.
Yeah. They don't put what the judge
Well,
is.
you look up what judge has been assigned to the case then.
The judges aren't assigned to cases. So you want to have that on the public website. You could go in front of several different judges pre-trial.
But there's an actual hearing date of like May 6th.
Yeah. It could be in front of a different judge that day. Those determinations are made by the local courthouse, who the judge is going to be in that courthouse that day, in that courtroom.
So you can't go to the courthouse and look up who's going to hear that case. You just have to show up at the.
You'd have to go into the courtroom. The proceeding is not closed. Just the file is closed.
Yeah. Well, it seems kind of weird that you don't know the name of the judge or the lawyers till you get there.
Yep. Yep. We just provide that information in compliance with the statute. Yeah.
Thank you.
Yep.
Another topic I might add is that the access that we've been given to the FDR for the record recordings, audio transcripts, has been pretty wonderful during the pandemic. And I wonder if there is any thought of having that continue after the pandemic, or if this was just a temporary, sort of adjustment that was made.
So Karen, Rhonda and I had discussed that briefly, and to be honest with you, we haven't had a chance to discuss it with all the players. I agree that it should be something that's discussed, and I can promise you we'll put it on the list.
Excellent. That's such a tremendous tool for accuracy and access, those recordings. So I thank you for considering that. All right. Anything else?
So Karen, may I speak up? It's Ty Erickson in court operations. So it occurred to me that I probably should have been the one to maybe comment on the housing. So we're keeping a close eye. I think your question was, what is our expectation once the moratoria are lifted with respect to both foreclosure and housing cases? We do have a fantastic group of mediators. They continue to mediate anything that's not covered by the moratorium, and anything that isn't going forward now. Once that's lifted, we will have those mediators in place still to look at those cases, and they generally are pretty successful in helping to settle those cases. We do anticipate an overload. There's no mystery about that. So we're going to do our best to get those items pushed through and hopefully help settle. We are relying on some possible eviction prevention funds when we mediate the eviction actions. Most of those cases are eviction actions, the summary process cases. So I apologize for not speaking up, but it occurred to me that I don't think anybody else is on from civil. So just wanted to offer that. So we're keeping a close eye on that.
Excellent. Thank you so much. Okay, I guess we should move on to the next item, which is the new meeting date, and that has been discussed as September 22nd. Rhonda, 3 p.m.?
That is correct.
Okay.
And I think it will probably be remote. I'm hoping 2022 we can get back to in-person meetings, but we'll see.
Karen, I add one thing? It's Melissa. So I wanted to let you know that I did check, and I'm happy to report that the rule that would permit the media to cover with a camera a sexual assault of a victim who was murdered was approved. And it's in practice book section 11-C, subsection Q, and I'll read it for you. In a homicide case involving sexual assault, the broadcasting, televising, recording, or photographing by the media of the trial may be permitted by the judicial authority, provided that the victim's family affirmatively consents to such coverage, that no member of the victim's family objects to such coverage, and that the victim's family has been notified. As used in this section, victim's family shall mean a person's spouse, parent, grandparent, stepchild, aunt, uncle, niece, nephew, child, including a natural-born child, stepchild, and adopted child, grandchild, brother, sister, half-brother, or half-sister or parent of a person's spouse. And that took effect on January 1 of 2021.
Wow, that's great. But has anybody had a case where the victim's family was consulted? Perhaps Linda Semino would know about that. Are you with us, Linda?
I am,
Yeah.
Karen. Hi. We have not been brought into that, so I'm not able to answer that question.
And Karen, we
Okay.
haven't received any camera requests to that effect.
Okay. All right. So to be seen, I mean, I sort of just based on experience, I would think that the families would welcome the cameras into the courtroom, but don't know until it happens. Okay. I think we are ready to adjourn. And Eric, I am passing the torch on to you and Judge Alexander. So good luck to you with that. And all in favor of adjourning?
Aye.
Say aye.
Aye.
Hi.
Hi.
Oh, okay, great to see everybody.
Good to see
Thanks, Karen.
everybody.
Take
Have
care.
a good
Thank
afternoon.
you. Bye-bye.
Bye-bye.
Take care.